type of government knowledge does Escobar's materiality inquiry demand? Knowledge of fraud allegations or actual knowledge of fraud?
Susan and I both, I guess, touched on this, and Susan did more deeply. From the defense bar's perspective, my answer is going to be easy. Knowledge of the fraud allegations. And I guess I'm applying a common sense view of that. If the government is aware of fraud allegations and doesn't look into them, that's the equivalent of the ostrich approach that can expose a defendant to FCA liability. So I believe knowledge of the fraudulent allegations is sufficient, and in particular, if the agency continues to renew participation or eligibility and pay claims after hearing about those allegations without doing anything, I think that'll be sufficient. I don't think you're going to have to prove actual knowledge, although every plaintiff's attorney will argue actual knowledge is required.
Thank you for that, Steve. Let's go to Maureen as time draws short. Maureen, do all courts require relators to allege such specific facts as to FCA allegations in their pleadings? And what if I don't have that level of detail?
Well, the answer to that is that it depends. Courts generally adhere to the Rule 9b standard that we discussed today, but other courts have recently suggested that they'd be willing to diverge from that standard. For instance, the District of Massachusetts last year held that a relator satisfied Rule 9b when he alleged he was told by a manufacturer's representative that a training was conducted via DVD instead of in person, and the in-person training was required under the relevant regulations. Some courts have also adopted a theory that a relator need not plead facts related to a specific claim in order to survive a motion to dismiss, and I referenced other courts that have held differently earlier in my slides, but an instance in which a court has adopted a theory that specific facts need not be pled is in a case called Grubbs, in which the Fifth Circuit held that the relator satisfied Rule 9b, where the relator did not plead the specific facts of a claim, but he did allege particular details of a scheme to submit false claims, and he paired that with allegations that led to a strong inference that the claims were actually submitted. And essentially, he alleged facts that indicated that false claims necessarily must have been submitted as a result of the alleged fraudulent scheme.
And with that, folks, we've run out of time, but we would really like to thank all of our speakers, Susan Hirschman, Steve Gombos, and Maureen McDonald, for a really fine job. Thank you all for your help, time, and support preparing for this event. And thanks for the attendees for being on the line, too.